Good afternoon, everyone. I just want to get things started. Welcome to the Columbus Board of Realtors class, Understanding Residential Real Estate Purchase Contract. I'm Katie McCartney, and I'm with Remax Affiliates, and I also am a part of the Education Committee here at the Columbus Board. A couple of housekeeping items. If you don't know, the restrooms are down the hall next to the bank of phones that are down there. And also, please turn off your cell phones and make sure that they are either on vibrate or off. And there will be a 15-minute break at 3 p.m. So you guys will get a break to go and hit the restrooms that I pointed out before. Make sure that you hand in the entire form after the class today in order to receive continuing education credit. There will be no exceptions. The continuing education credit certificate will be given to each student immediately following the class. In most cases, their CE evaluation form still needs to be turned in after this class before they receive their certificate. Also, if you're unable to hear the instructor or the room temperature needs adjusted, please don't hesitate to bring up those needs to myself or any other Columbus Board member here. Now I'd like to introduce Bill Ferguson. He is a partner with Peterson, Ellis, Fergus, and Peer, LLP in Columbus, Ohio. Mr. Fergus practices in the areas of real estate law, auction law, business law, estate planning, and probate law. Prior to entering a private practice, he served as corporate counsel for a variety of companies, including large independent land title agency and 2 communication companies. Mr. Fergus is a frequent lecturer for continuing education programs on real estate law and auction law. He is a member of the Columbus Bar and Ohio State Bar Associations and is a member of the real property and probate subcommittees of each. Mr. Fergus holds a bachelor's degree from Ohio University, a master's degree from The Ohio State University, and is a graduated magna cum laude from Capital University Law School. So we all like to welcome Mr. Bill Fergus.
Thank you. Let's see. Okay, now, everybody here? Yes. Good. A few ground rules. I know that business is bad right now. Nobody out here can afford to miss a call, so I understand it. If you need to leave for a call, just be real quiet about it. I don't mind. Just be considerate of the people around you. Also, my style is fairly freewheeling. This is my first crack at teaching this particular course. You're the guinea pigs. If you have any questions, feel free to ask. I will try to repeat your question because this is being recorded, so bear with me a bit on that, and hopefully we'll get through that aspect of it. Before I start, anybody have any questions? Okay. Typically, the way you're supposed to start these things is with a joke. Here we go. A woman walks into a post office one day to see a middle-aged balding man in a 3-piece suit, standing at the counter methodically placing love, quote-unquote, stamps on bright pink envelopes with hearts all over them. He takes out a perfume bottle and starts spraying scent all over them. The woman's curiosity gets the better of her. She goes up to the balding man and asks what he is doing. The man says, "I'm sending out 1,000 Valentine cards signed, guess who?" "But why?" asked the woman. "Because I'm a divorce lawyer." Desperate times call for desperate marketing measures. And these, and I know these are desperate times in our business. One other thing I should tell you about myself is that my wife has been a real estate agent longer than I've been a lawyer. So I do understand your concerns, and I hope that's reflected in this presentation. But first of all, we'll get through the advertising, since I'm a lawyer. We'll talk about the roles of lawyers and realtors, and indeed the roles of realtors and any professionals, because it's my opinion, and we'll get into this in more detail as we go on, that the most successful real estate agents that I've run into retain a team of professionals to assist them, and that team's not very hard to assemble. In the case of attorneys and realtors, let's remember one thing. As real estate agents, you are sales and marketing professionals. And anybody who doesn't respect that is foolish. Okay? I mean, you'll run into people say, well, what are you doing as a realtor? Well, actually, I'm a sales and marketing professional, is your reply. And you bring professionalism in everything that you do. I'm a legal professional. You're not. The Supreme Court recognizes this. This case that I've cited here is from 1941. It's an Ohio Supreme Court case. Merely using pre-printed blank forms is legal. Supplying simple factual material is not the practice of law. What the Supreme Court is saying, though, is you go beyond that, and you may be practicing law. This is good law. This is still the law today. Ohio Revised Code Section 4735.62. That's part of the real estate agency statutes. Talks about advising the client to obtain expert advice when necessary or appropriate. When's it appropriate? Look at your realtor canons. The licensee should recommend that title be examined and legal counsel obtained. So my advertising at the beginning here, and I'll try not to dwell on it too much, is consider using a lawyer in your transactions. Consider recommending a lawyer to your clients. Getting a lawyer involved will actually keep your client, and most importantly to you, keep you out of trouble and enhance your professionalism. And that's true of several other disciplines as well, and we'll get into that. But back in the real world, where many, if not most, transactions don't involve an attorney representing the buyer or the seller, you can represent your clients better by having a better understanding of this real estate contract, the CBA, CBR real estate purchase contract. So let's start off with a couple of there it goes. Clip is broken. Okay, is that any better? Is that any better? That way I don't have two things going on at once here. A couple of introductory concepts. The statute of frauds. When you went to school to get your license, they talked about the fact that everything you do needs to be in writing. And that's the legal basis right there. Real estate, under Ohio law, real estate contracts have to be in writing, signed by the party to be charged. In this case, it's both parties. Okay? So everything you do is in writing. You know that. Merger is the other concept here. Towards the end of the contract, and we'll talk about it more later, it says this contract constitutes the entire agreement. So everything that you've agreed to and you've agreed to previously needs to be in the contract right now, or that agreement's just simply not operative. Contingency clauses. Your real estate contract is literally filled with contingency clauses. And in fact, when you write an addendum or anything you add to the contract, in many cases, you're writing a contingency clause. And if you take nothing else away from this, I want to talk to you about the different kinds of contingency clauses and how to write a good one. Because that will keep you out of trouble, and that will make a transaction go more smoothly. When you write a contingency clause, or let's talk about it going forward, when you look at this contract, think about what happens if a contingency is not met. What's the consequence of not meeting a contingency? Excuse me? It can be out of contract. You say the consequence of a contingency is that you're no longer in contract. Consequence of a contingency could be that you waive something. Right. You waive your rights. When does it happen? A good contingency clause is going to tell you when that happens. Sometimes a contingency clause will be self-executing. In other words, it says, if this does happen, then this happens. If this doesn't happen, then that happens. It doesn't leave it up into the air. Or it's an option. If this doesn't happen, then the other party can do this, that, or the other thing. And hopefully it also says the other party can do this, that, or the other thing by a date certain. Or they waive their right to do this, that, or the other thing. So keep an eye on this as we go through the contract. All right, last plug. Follow along on the handout, the contract itself. Ideally, what I'd like to do for those of you who are interested, take that contract, note it. Just take notes right on the contract, and hopefully when you walk out of here, if I've done my job, you'll walk out of here with an annotated contract that goes through some of the issues we talked about today, and you can refer back to it whenever you have any questions or just want a little refresher on what we're talking about. Last plug, represented by a realtor and an attorney. Enough said, won't talk about it again. First issue. Upon the following terms, the undersigned buyer agrees to buy, seller agrees to sell premises. The tax parcel is important here, okay? You need to know, and the parties need to know, exactly what's being bought and sold. I have seen transactions where somebody just described it as a street address, the deal goes through, someone goes back and says, I thought I bought that part of the property. Oh, well, no, you didn't. That belongs to the neighbor. But it has your address on it. Well, sorry, I didn't have title to it. The only way to know for sure what you're buying and selling is to get those tax parcel number or numbers in there. Especially if you're buying or selling rural property, or you have more than one building on a parcel that you're buying, you need those parcel numbers. You can get them through the CBR website. You can get them through the county auditor's website in counties that are online, which is most of them now. Or you can get them through a title agent, especially you listing agents. A title agent, when I talk about that team of professionals, a title agent is perhaps the most important member of your team if you're listing property. I can't stress how important it is, whoever it may be that you trust, find a title agent that you trust and you can establish a relationship with. As we go through this course, you're going to see how often it is, how important it is to have someone you can go to when you've got issues. What's that? I'm not... Date the contract? Someone said I missed the most important part. They're probably right. Date the contract. That's absolutely true. And the real bottom line with the contract is that the contract may be dated up front, but what you really need to have in the date is at the rear when you go into contract. Mm-hmm. Yes, sir. The most important thing is the tax parcel. To the extent you can make an additional description, classically, if I write a contract, I'll write property located at or commonly known as 123 Main Street and all appurtenances located thereon. You're allowed to use any legalese you want, as long as you get the parcel numbers that you're selling. That's the key, because that which is attached to the parcel is part of the real estate. Yes, sir.
In that description, is it important to describe it as a single-family, multi-family type property, or vacant land, or financing, or whatever?
Again, I would say that any accurate additional information you can put in there is useful, but the most important thing is the tax parcel number, because otherwise you're not really sure what you're buying, because it's the underlying property that's the issue, right? It's the dirt that's the issue. Lender pre-approval. Note that there are very specific requirements for a pre-approval letter. If you fill in this number of days here, there are very specific requirements. They pre-approve subject only to an appraisal, standard qualifications, which means are they creditworthy, and final underwriting approval. What happens if the letter is not delivered in a timely manner, or if the letter doesn't have the right content, arguably? If the buyer doesn't deliver it in a timely manner, contract shall terminate. This is the one piece of true seller protection in a contract that is mainly written for the protection of the buyer. And when we talk about this at the Bar Association, the fellows who were in on the original drafting of this many years ago, it's undergone a lot of changes since, talk about it principally as a buyer-oriented contract, but this protects the seller. This makes sure the buyer's serious. So if they're not serious, we get the house back, close everything up and get the house back on the market. This is a self-executing terminating contingency. Automatically takes place. Nobody has, the way it's written, you absolutely know what's going to happen. Loan commitment. Now this one generally protects the buyer. The buyer is going to use good faith, about in the middle there, shall use good faith and reasonable efforts to obtain a loan commitment. Now, in the current market, the word commitment doesn't seem to mean quite what it used to mean. We're seeing lenders that will commit, quote unquote, to a loan, only to have underwriting come back 2 days before closing and tell us that the that the property doesn't appraise properly and they're withdrawing. So take it for what it's worth. If the lender doesn't perform, there's not much anybody can do about it. But again, if the loan commitment's not forthcoming in a timely manner, this too has the same kind of contingency, has the same terminating contingency if you don't get these things done in a timely manner. So the agents need to stay on top of this process. Good faith is an implied term of every contract. You're going to see that a lot in here, and sometimes you'll see specifically what it means. Attorney approval clause. Assuming an attorney is involved on either side of the transaction, what can the attorney do? Note the part that's highlighted in red. The attorney can disapprove the contract, but he's also obligated to write in changes to remedy the disapproval. So as an attorney, I can't simply say to the parties, well, I don't like this contract, or my client calls me, let's say it's 24 hours after the contract, my client calls me and says, I've got this contract, I made a deal, I don't like it. It's just a bad deal for me. I want you to disapprove the contract. Well, I can't simply do that. Now, being an enterprising attorney, I can probably find 20 other ways around it, but this is not one of them. So if an attorney disapproves the contract, you get an attorney involved in a deal and they disapprove, they've got to have grounds to disapprove, and they've got to say, you can fix this by doing X. And if you do X, then I'll approve the contract. That's required here. Real estate taxes and other assessments. This is where a seller can start to run into trouble. If your seller's delinquent and you get into contract, say they're delinquent on taxes, they got to bring those taxes current. Doesn't mean the contract terminates if they don't bring it current. What it does mean is they're in breach of contract. If they're unable to bring it current. Community development charges. These are relatively new, and you'll see in a minute that it's important to know what they are and to know if they apply to your property. How do you know? Once again, it's that title agent. Remember, in Ohio, by the way, I'm sure you're aware of this, having been to the closing table, all taxes are paid in arrears. So there's always going to be taxes that are due and payable because they're paid in the past. So that you're going to be, remember that at closing you're crediting the buyer in order to pay the seller's taxes going forward. It's just the way it works.
What happens if the seller has to come to the table with money and they owe taxes in arrears? Does that stop the whole thing? Do they get hauled off to jail? What happens?
Well, they're not going to get hauled off to jail. They're either going to come to the table with enough money to clear the taxes, or the transaction may not close, and they're in breach of contract.
Okay. Well, what would happen to them if they're in breach of contract?
Well, they could get sued. That's
So they have no
yeah,
money, so-
right. Well, that's right. That's right. I mean, and that's a. What she's saying is that. And
What does the buyer?
go back over this because again,
Yeah.
I apologize to everyone here. The discussion is what happens if a seller comes to the table without enough money to clear the tax bill. They either clear the tax bill or the transaction may not close. Or the seller may clear the tax bill, or the buyer may clear the tax bill and then turn around and sue the seller for the difference. Now, it's a breach of contract to not have the money you're supposed to have to be able to close. No question about it. Consequence is, if they don't have any money, it's hard to sue people without money.
So the buyer's just out of luck. The buyer just either pays it themselves or they don't buy that property. They get to close it and don't buy.
Well, that's right. The buyer is out of luck, and probably the best thing the buyer can do is to have full information about the property as soon as they get into contract. And not to beat a dead horse, that's where the title agents come in. Okay? In the current market, bad things happen all the time. We know that. People are selling short. Sellers don't have enough money to close. There are liens, hidden liens, liens the seller knows about, don't want to tell you because they think you won't work with them. And then they crop up later on and the seller goes, oh my gosh. Well, and they probably knew about it. Sometimes they don't know about it. The best thing to do is get that information in advance. And I think my opinion is, as a selling agent, unless you're awfully confident of your seller, the best thing you can do is once you sign up a listing, go to your title agent and say, I've listed this property. We will be closing through you unless something unforeseen happens. Get me a commitment. I want to see what's going on with this property. Best thing you could do. Now you know what's going on. Now you can tell the buyer what's going on in advance. Now you can ask questions of the seller. What about this lien? What's going on here? All right. Yes?
What happens if the taxing authority, after the closing, goes back and says, well, the square footage was off, we're going to go back over 10 years and reappraise the tax value for that period?
I don't believe, for starters, I've never heard of it, first of all. Second of all, I'm virtually certain that they cannot reappraise backwards over a 10-year period. I've never heard of it. I mean, they can make themselves intensely unpopular doing something like that. But remember that under the contract, and you'll see this later, well, it's not under the contract, under your basic closing documents, the title agent is going to tell you that as between you and the title agent, you accept the current value, and that's how we prorate taxes. Now, if you go backwards and they say, well, you owe for 10 years of taxes because this property supposedly had 1,400 square feet and it actually has 2,400 square feet, and we're going to revalue the property accordingly, you got an interesting situation because those taxes were owed by the previous owner. You're going to get it out of the previous owner's hide. Good luck with all that. Legally, yes. Realistically. Any other questions? Yes.
I have a question on assessments. It says they have to be paid in full. Do you have super assessments that can be quite large, water assessments can be quite large, or like if you just got your street money? What's the rule of thumb that says that has to be paid? If it's a super assessment,
Well, if it's a sewer, are you talking about? Right, and you're not talking about having paid, let's say that they put the new sewer system in 2005 and it's assessed till 2025. You're talking about through the assessment through the date of closing, that portion through the date of closing, because you're getting the benefit from the buyer is getting the benefit of an assessment, presumably from the date of closing going forward. No, you're not looking at all those future payments piled into it. No. Community development charge. Since 2001, Chapter 349 of the Revised Code permits developers to assess properties in a development to fund an integrated development plan. I read the statute yesterday in preparation for this, and it made my eyes cross. The very short version of it is that a community development plan, like they call it all right, I forget what they call it. Never mind. But a community development plan, though, is like a homeowners association on steroids. And the charges can be pretty significant. Whereas a typical HOA charge will run from $60 to $200 or $300 a year, these things can run north of $1,000 a year. And they're organized in a similar manner. You've got a nonprofit corporation that is designed by the deed restrictions and has trustees, and eventually usually the developer controls it until they've managed to sell off the development, and then the property owners get to take over at some point. But the difference between this and a homeowner association is that this is a statutory creature, and the statutes provide that when you're selling your property, you've got to let the buyer know that the charges are there and where to find the statutory, or where to find the recorded authority for the charges. Otherwise the contract could be unenforceable. We'll come to the closing table, nothing happens, and it's on you, seller, because you didn't provide the information. One more time, yes. Is that going back to the title agent as a question? The answer is yes. If you get that search done right away, you're going to know about that community development charge, and you'll be able to provide full information to the buyer.
It should be disclosed on the MLS too.
And you typically, but it can be up to the listing agent. And then again, when you list, if you don't disclose, if you don't know about it, you're not to disclose it. It's that simple. Yes, sir. Excuse me? It's not the same as an impact fee, no. Community development charge is very specific, and it refers to this one section of the code for this one purpose. Yes, sir. Yes. A change in the you ask if it has anything to do with a change in the condominiums?
Right. They have something new coming on now in the condominiums. The condominium association has to have certain standards.
Well, it doesn't have anything to do with condominium standards. In fact, it really doesn't have anything to do with the condominium statutes at all. You say, well, yeah, the condominium association is supposed to keep a reserve, and we'll get into that later on in the presentation, because condominium, doing a contract for a condominium is a special problem for a variety of issues that we'll get into later that you need to pay special attention to. But that's for the second half. Anyone else? Okay. This is generally not part of the public record, and this is something that you've seen, that seller's affidavit that sellers typically sign. This is usually one of the subjects that it touches on, because these have a tendency to be off-record matters. In other words, you can't find it in any recorded instruments. But it's something they ask your seller about. Is there anything going on here that's been installed, that you've been notified about future improvements, that's something that's going to be charged for the future that you know about? and you need to disclose that. Is that Wilma back there? Hi, Wilma.
If you write the offer and the seller knows of the community development charge, do they write it in here, the seller? Or is it on an addendum, or how is that?
The seller should, Wilma, the seller should write the community development charge information right into the contract. Because you've got the blanks there, just write it in. If you know it, write it in.
Representing the buyer.
Excuse me?
You're representing the buyer and you give the purchase contract to the seller's agent. The seller then takes it and writes it in here.
Well, he could either write it in or he could write it in. My recommendation, if you hand him a contract, go back and say, there's a community development charge, and just use the same information and notify them right away. Per the way I'd write it up is in your counter offer, there's always going to be a counter offer. Please note that pursuant to section 2.2 of the contract, there is a community development charge. It's formed by instrument number blah, recorded blah, Franklin County Recorder's Office.
Okay, so the seller writes that in on the counter.
Yeah. 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 Fixtures and equipment. Equipment is a vaguely defined beast. I'm uncomfortable with the word, but it's there, and especially when you talk about including but not limited to, what becomes equipment. Generally, the things that are listed in this paragraph and anything else that's affixed to the land constitutes quote-unquote fixtures and equipment. So if it's bolted into the wall, it's a fixture. Anything that's permanently affixed to the land. There were two things that I noticed going through here, and one of them came from problems that one of my partners had in the past. There's a discussion of leased equipment here. For example, water softening equipment, security systems, satellite TV systems. That's good as far as it goes, because you should be on notice that if something's leased, it's not part of the land. And in fact, the seller it should put the seller on notice to say, wait a minute, you may be counting on this water softening system, but it's not part of what I'm selling because it's leased. But there are other things that can be leased too, and this is something you need to be careful about. My partners had two deals, which I find amazing, but I guess it's out there, where people had leased hot water tanks. Apparently it was common at one point or another for the utility to be leasing out hot water tanks, and surprise, surprise, the utility, they buy the house, and surprise, surprise, the utility comes back and says, oh, by the way, you owe us lease payments. You don't want that surprise. So, be careful. Ask your seller what they have on the property that's leased when you're a listing agent. When you're a buyer, ask the question, you got anything that's leased? Are you sure? Yes, sir.
Why did you say that some of the more common ones are satellite systems, water softeners, and what else did you mention?
Well, they mentioned in the contract, they mentioned water softening equipment, garage security systems, satellite systems. But we have noticed hot water tanks. Not in there, but that's one of the things we've noticed. You mean a flat screen television that's affixed to the wall? Good question. Yeah, you might. If I'm the seller, I certainly want to clarify that even though this thing's fixed to the wall, I'm not selling it to you. I'd make that real clear. Because I know a lot of them now write. I mean, they're just, they got the wires through the wall, they bolt the thing into the wall. Yeah, it looks like it's permanent to the house. Be careful. Yes? So you're talking about a whole house stereo system. Okay, so you've got let's see, from the example, what I'm familiar with, you've got a bunch of speakers, and you got sound controls in the wall, and you got a plug, right? You have a plugging system, and then you can plug any unit you want into the plugging system. Right, but at the central area, it's modular, and you can take any properly equipped stereo and just pop and plug it into the wall and use the speakers. I would certainly think the stereo is not a fixture, but again, what's the best thing to do? Write it into the contract. Speakers stay, receiver goes. The other one that caught me here was I only got part of this done in red. Storm and screen doors and windows, awnings, blinds, and window air conditioners, whether now in or on the premises or in storage. How do you know what's in storage? But that's what it says. Just seems like an invitation to trouble to me. Yeah, it starts. Start with the semicolon after kitchen fixtures. The whole thing goes. All goes to there. So it's all those things, whether on the premises or not. Yes, sir. Yeah, he says pay attention to what you have those rollout window, rollout awnings or rollout patio covers they sell now. That someone may take them and just put them in storage for the winter. Yeah, be careful. I mean, that's covered under that clause. So something to ask your seller about. Although again, who knows? How do you know what's in storage? How's the buyer know what's in storage? It's a bit of a strange paragraph. I love this contract. I studied the heck out of it to do this class. Nothing teaches you better than having to teach something, but nothing's perfect, and that's a little strange to me.
Is that something that can be
You could certainly strike it and initial it. I mean, you get the other party to initial it. You can strike it out of there. Yeah. You all understand if you want to strike anything in a contract, the best way to do it is to strike it, put initials so that all the parties initial right next to the strikeout. That way everybody clearly recognizes what's there and what's not there. Moving on. Inspections and tests. The broker strongly recommends the buyer conduct inspections and/or tests. Recently, I had an agent tell my client, "You don't need to do tests. You don't need to do inspections." That is so foolish. That's right. That is so foolish because you're the one being protected. You are the ones being protected. There's simply no doubt about that. One thing I'm going to tell you is that you're going to be, and we'll get into this later, you're recommending a professional, okay? Be careful when you recommend professionals. And we'll talk about that more later, but if you are too forthcoming in your endorsement of someone, that can end up being the grounds of a lawsuit. We'll talk about that more later. But yeah, from the laughter, I can tell that you all are, I'm preaching to the choir here. make them get an inspection. Even new properties, if they're building a house, if they're stick building a house, they should have an inspector. If they're buying a spec property that's never been lived in, that just got completed, it should be inspected. Anything should be inspected, because anything can be defective, no question about it. Humans build it, that's right. Humans built the house. Things can go wrong. So let's look at this, because this is the most technical part of the contract and the part you really got to be careful with. And this is the part that's been changed in the last couple years. The specified inspection period. You put a number in there. That number gives the amount of time that the buyer has to get the property inspected and to get a report of that inspection to the seller or the seller's agent. That's the specified inspection period. All requests to remedy shall be submitted within the period. Time is of the essence. What happens if you don't do it? Answer? Answer is you've waived it. If you don't get the inspection report in a timely manner, you've waived it.
I have a question.
Yes, sir.
In 4.3, we're going into a holiday weekend, so I want to say the buyer shall have 9 business days. Do I have to strike calendar, or if I put 9 S in that blank, am I okay?
Well, I'd strike calendar. I think the best practice would be to simply calculate how many non-business days there are and just reload it as calendar days.
I don't know when the contract's going to be accepted, so I'm going
Okay.
to a long weekend, so I generally use business days, so I don't know.
Well, then strike calendar and put in business days. And I'd even say business days excluding weekends and holidays. You know, be real clear about it. More, sometimes, not always, but sometimes more words are better than less.
What have you recommended for that?
Excuse me?
What have you recommended for that duration of time?
The question is what would I recommend as a duration? It's a little hard to make a recommendation of that because you simply want to leave enough time to make sure that you can get an inspector out there and get an inspection report and be able to look at the report. And that's a subject of negotiation, but I would certainly leave at least 10 calendar days. Well, hopefully, if I'm the buyer's agent, I'll put in 15 business days. If I'm the selling agent, maybe I want to go a little faster, and we go back and forth and come up with a number of days, and that's that. It's a negotiation. The time period begins at the time you actually go into contract, which means the date and time that you have let's say, a counter offer that's been offered by one party and accepted by another party. The time of acceptance of that last offer is the time you go into contract. Unless, of course, you can also agree in writing to say the effective date of this contract is blank. Then that's the effective date.
I always go by the date on the signature.
Right. Going by the date on the signature is fine. Like I said, the last party to sign, the later of those two signatures is the time of the contract. Yes?
What if you asked for 7 days and they actually got an inspector in on the 4th day and they found mold and the buyers are like, if it's not toxic, we can go through with it, but if it's toxic, we don't want to buy it. But the mold inspector can't come out till 4 days from the date that they found out, which is the 8th day, and they won't get the report till 2 days afterwards. So what happens?
Okay, so basically you put together a scenario where you've done an inspection, an initial inspection. It's raised some issues. In this case, you're raising mold issues, and you feel like you need additional time to inspect. Okay, as the buyer's agent, now you say, well, now what do I do? Because that additional time is going to run me past the contract date. Your choices, you have two choices, and you'll see it as we go through it. We have two choices, which are to either, you're going to come to the seller and say, here's the problem, we need in writing to extend this specified inspection period to X amount of time, okay? So you either agree to it, and if they won't agree to it, now as a buyer you got a choice. Well, they won't agree to that. Now I have questions. What do? You might want to get out of the contract, which is your right, as you'll see. But that's the way that works. I mean, you have to go back and get that inspection period lengthened. And if you can't do that and you feel like the questions are too big, then your buyer may want to bolt. Yes.
Question about the days in the contract. Is day one the day that the final party signs, or the first following day? So I had a party sign a contract yesterday. Is today calendar day one of this process, or was that yesterday, the day the party signed?
If you know, it's you do this exactly, okay? You might notice that on this contract you have date and time, okay? You ever notice that? It says date and time. You go into contract, if you follow that regimen properly, and you should, then you go into contract at a time certain, okay? Doesn't, they used to, maybe they changed that on me since, one I didn't notice. Yeah. 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 The day you go into the contract, if there's no date, if there's no time on the contract, and I'm just thinking of my own contracts, because I always use time on mine. If there's no time on the contract, a court of law is generally going to give you, assume that you made that contract at the end of that particular day, and so the next day is the first day. Yes.
The wording there actually says certain calendar days after the date of written.
Right, and it implies that that the clock starts at the end of the day at 12:01 a.m. the next day. Yeah. And that might be why they got rid of the time thing in the old contracts. That's actually a better way of doing it. Anyone else? All right, moving on. Okay, so we've had our inspection. If the buyer is not in good faith, there are those magic words again. And this time you'll see later on, the words good faith here have a pretty specific meaning. If the buyer is not in good faith satisfied with the condition, then they can proceed under 4.4a or 4.4b. Agreement to remedy period. So, whenever, it's not whenever, let me correct myself here. It's not whenever the buyer's broker delivers to the seller's broker the request to remedy. It's the buyer and seller shall have blank calendar days after the end of the specified inspection period. So, the specified inspection period runs for 14 days. The agreement to remedy period runs another 7 days. You deliver the inspection report and request a remedy on day 11. How many days do you have left? 10, that's right. Now the interesting thing about the way this is written is that look in the middle of this one. Once you've received, once the buyers have sent a request to remedy, the parties have to act. Somebody has to do something here. So my example, we've got those 10, inside those 10 days that are left, either the buyers and sellers have to agree on a remedy, or the buyer terminates or the buyer agrees and waives the request to remedy and just agrees to go forward with the contract, or the contract automatically terminates. So you can't sit on your hands on this one. As everyone, again, this is preaching to the choir, I'm sure, as everyone's aware, the seller doesn't have to remedy. They don't have to do anything. The seller always has the right to say no, buy what I'm offering you, or don't. But this is this is it. Or they can make any offer in between. If you don't have a meeting of the minds, you don't have a meeting of the minds. Buyers get their money back and everybody walks away. As long as the buyer has followed the time limits here, again, that 21-day period I talked about, as long as the buyer has followed the time limits during any of this period, as long as the buyer has a good faith reason to believe that the premises are in need of repair, the buyer can terminate. The buyer can walk away and say, okay, I sent you a request to repair, but now I've decided, no, I just can't buy a property that needs that kind of work. And that makes me uncomfortable. I'm out. The mold can be remediated, but I don't want to take that chance of the mold coming back. I'm out, and they can do that. But again, here's the most important. They put this in bold and caps for a reason. Two things here. First of all, good faith is in that first sentence. A buyer that tries to walk out of the contract based upon cosmetic or non-material conditions, I don't like those nail pops. Or there's a dent in that drywall, right? That's bad faith. No question about it. And good faith is a term of the contract, and that's a breach. Also, that second sentence, failure of the buyer to deliver written notice to either deliver the remedy, have the test done in a timely manner, deliver a request to remedy, deliver a notice of termination, any of those things, he waives it. Waives his right to terminate. Constitutes acceptance of the condition of the premises. Yes?
I have a question. Lately, I've been seeing on the MLS for bank-owned properties where it's stated that the inspection for a buyer is just based on their knowledge because the property is being sold as is. So is that saying that
You were asking about bank-owned properties, which is, again, kind of it's a beast that we're running into more and more, and a real problem for you guys. I know that. And one aspect of that problem is that the bank is selling a property that, generally speaking, they have no idea what they're selling. All right, other than a building and a land, they don't know much more about it, and they're not going to make any warranties or representations whatsoever about the condition of that property. Now, you ask what they tend to put in their contracts as far as this. They have an as-is provision, right? You're taking it as is based upon your knowledge. Just be careful. As long as you have this contract and you say accept as is, you still retain, unless they say you're not allowed to inspect, or these inspection provisions are amended, you still have the right to inspect. All they're saying at that point is you can inspect, and if you want to walk away, fine, but we're telling you in advance we're not doing anything. Now, if you have any doubts whatsoever as an agent as to what they're saying, any doubts whatsoever, in your counter proposal back to them, just say, buyer understands that you're selling it as is, buyer still wants to inspect pursuant to Section 4 of the contract. If buyer's not satisfied, buyer can walk out pursuant to Section 4. Be clear, more is better, so you understand each other. Yes?
We skipped additional terms and conditions, I'm sure on purpose, but pursuant to this lady's question, that's what I wrote down. Are we now beginning to practice law? So if I put in additional terms and conditions, seller's notification of as-is condition of property does not in any way negate buyer's rights under paragraph 4 of this contract. Am I practicing law now?
Well,
Am I protecting my client?
let's put it this way. If you wrote it correctly and you practiced law well, you're protecting your client. If you wrote it badly, you're practicing law and you're not protecting your client. The best thing to do would be to advise your client to get an attorney. And as we'll go through in a while, writing things that are outside of your standard terms and conditions is not as easy as it looks sometimes. You've got to be very careful. You've got to be a good writer. You can really get yourself and your client in trouble. All right, I lied. I'm advertising again.
We're keeping a hash mark list, so that's all. You're up to 6.
I'm up to 6 now? Okay. I'll make double figures, don't worry. Moving on, warranty, Section 5, Section 6, there's nothing particularly controversial here. Most of you sellers or agents are going to put a home maintenance plan in here because you profit from it, which is fine. It's a good thing for everybody. Not a problem in the world. Use a reputable company. Same with the gas line warranty. You usually don't profit from that, but it's a perfectly good idea. Not particularly expensive. Should be there. But let's move on to title insurance, because I think this is something that most agents understand, and in fact, most lawyers fresh out of law school, I assure you, don't understand. Under this contract, and this is per local custom, if you go to a different part of the state, things are done differently. You go to Cleveland, they split the cost of title insurance. Go to Cincinnati, they don't have title insurance for the most part. Go to some other areas, the buyer is buying the title insurance. So it's just different in different places. This is our custom. Seller furnishes and pays for a title insurance policy. Fair enough. The more important stuff, though, in this paragraph, title evidence shall show the seller in marketable title. Fee simple, free and clear, all liens and encumbrances except what's listed there. And then there's that seller's affidavit that I talked about sitting at the bottom. The seller's affidavit that they sign it, that you see them sign at closing regarding off-record matters. This is where your sellers can really get into trouble. I was talking to an agent this morning who has a screwed up deal right now because the seller didn't tell the selling agent that they were being foreclosed upon. They didn't get the title work done. You get in the contract, you get a week or two out from closing, and say, oh, we got a cloud on title. It's a big cloud. You're foreclosed upon, and there's been a default judgment taken. So now you got a problem. This is where I say get a commitment done in advance, because as we see in the next one, marketable title, by the way, that's a great phrase. Marketable title generally, let me get to, try to read up on that one. Title sufficient to withstand any reasonable legal challenge to the owner's peaceable control and ownership. It's a complicated area of law. It's kind of what title insurance underwriters say it is, unless there's a court case on point. Because unless there's a court case, you've got to find a title insurance underwriter who says, well, is that a cloud on title that makes it unmarketable? Well, no, I'll write insurance over it. I won't accept it. I won't take an exception to it in Section B of the commitment. Well, then it's marketable. Okay, if they do take an exception to it, then you might have a problem. Okay, but the person who's going to tell you that is, again, the title agent who does the search and writes up the commitment. The problem here is that a cloud on title like this is not a reason to terminate the contract. It's not like the seller can say, oh, well, I didn't know this was here. I guess we can't do the deal anymore. No, this is a breach because the seller shall, within 30 days, remedy or remove the defect or obtain title insurance without exception. So these kind of defects can really get your seller in trouble. So it's best to know about them in advance. Oh, go back for a minute. Here's a good one for you. Some of these things, I've thought of an example. Any of you familiar with the Lake of the Woods? Anybody ever done a deal there? Anyone? Okay. Seeing no hands. Lake of the Woods is in southern Delaware County. It's a nice subdivision right on the other side of Hoover Reservoir. What's unique about the Lake of the Woods is that they have deed restrictions that give the existing owners in the subdivision a right of first refusal anytime a property is sold within the subdivision. So, out-of-town title agent selling a bank-owned property doesn't see this in the restrictions and simply goes forward and sells the property. Now you've got yourself a real problem because the enterprising local owners who were looking at this very attractive underpriced property swoop in and say, wait a minute, you didn't give us our right of first refusal. Now, local title agents know better for the most part. If you have someone, an experienced local title agent sees Lake of the Woods and alarm bells go off, and they know that before you go into that contract, that you need to put in your contract with the buyer that this contract is subject to right of first refusal contained in deed restrictions, and that the seller is going to work to obtain obtain waivers of those rights. Because what the title agent's going to have to do is they'll have to send out a bunch of letters to comply with the deed restrictions. It says to all the local, I see an incredulous look in front of me. It's true. This is how it works. They have to send letters to everybody in the subdivision. Says, this is being sold. You have the right to make it. You have the right of first refusal. Must be exercised by X date. And once that date passes and they haven't exercised it, now you're free to sell.
Did they have to give a reason why?
Excuse me?
Did they have to give a reason why they reviewed it?
Why they?
Refuse to sell.
Why they don't want it sold?
No, it isn't that they don't want it sold. They have to. It's a right of first refusal, Wilma.
If the residents say they don't want to sell it to that person, do they have to give a reason?
No, somebody has to buy it. It's a right of first refusal. It's not a right of rejection. In other words, they can't. No, rights of rejection were right. It's a right of first refusal. So they can basically walk in, they can step into the shoes of the buyer and buy on the exact same terms and conditions that the buyer is buying the property. Yeah, those kind of restrictions were made illegal by the Supreme Court back in the 1940s. You can't do that anymore. Yeah.
I assume that letter would be written by the attorney of the title company. And
Yes, typically that's a service the title company will perform for you. Typically. They don't have to. Typically they'll do that.
a certain amount of time that they would have, is that set anywhere, or is
Properly, as I remember the deed restrictions, I didn't pull them. I didn't pull them to take a close look at them, but as I remember how the deed restrictions were written, they have time frames written into the deed restrictions. So they say notice has to be delivered. You have so many days following delivery of notice to exercise it. If you don't exercise it, you waived it. Yes.
Question regarding Chicago with all the short sales out there, and I have two in particular that just all of a sudden either got liens from credit cards or tax liens, personal tax liens attached to the home that were 30 days, less than 30 days prior to closing. So if they can't get those rectified beforehand, is the seller obligated at any point, or would they just go away and just don't get to sell the house?
Okay, the question is regarding tax liens that are put on the property within some period prior to closing. Any liens that get attached to the property. It's a breach, yeah. Again, this kind of goes back to what we talked about earlier. There's definitely in a short sale situation, we're going to go through the short sale forms later, okay? Because I think those are really good. They're really valuable for a process that people don't understand well and have good reason not to understand well. But suffice it to say that if you're in a contract, even in a short sale situation, and the seller says the seller shall clear all liens, and he can't clear the liens, then yeah, he's breached the contract. As the buyer, almost by definition, the seller's broke. So, what are you going to do about it? Yeah, there's not a remedy for every wrong, is what we like to say in the law. It's wrong. It's they defaulted. They're in breach. Is there any real remedy to it? Well, not if they don't have any money.
Is there the possibility of suing someone to perform as a seller?
You're asking about suing to get someone to perform on the seller side. The short answer is yes, definitely. There is that possibility of forcing a seller to perform, at least in terms of conveying the property. I mean, in terms of getting them to make payments so that they can convey the property. If they don't have the money, they don't have the money. But if they just say, we're not going to perform, we've changed our minds and we don't want to sell the property, we'll talk about that. Save that one for section 10 when we talk about the earnest money deposit, and we'll bring that back up. One of your favorites, eh? Okay. But yeah, get it. That's my big preach for the day is write good contingency clauses if you're going to write them, and as a selling agent, get yourself a good title agent and get your title searched right away. Damage or destruction to the premises. You've gone into contract and there's a fire, or Hurricane Ike hits and beats the house up pretty good. What has to happen? And this is very specific, so you really got to be careful with this. As a selling agent, you got to give notice after the discovery of the damage. And it's got to be 2 days, 2 calendar days from the date of discovery of the damage or destruction. Once that notice is given, then it's on the buyer. The buyer can proceed with the transaction and get the insurance money, or he can rescind within 10 days. If the buyer doesn't make an election, he's elected to proceed. So if he doesn't make an election, he's elected A. That's a 9.2. 9.3 is the one that's a little unnerving. Let's say that your seller is underinsured. Now you got to be really careful because this has a bonus. If you don't make the timely notification regarding the damage or destruction, your seller could be on the hook for magic words that aren't in the previous paragraphs, reimbursement for repairs. So if you have a damage situation, be careful to make that notice and make it right away.
Is that something the title agent can tell us?
Well, no, this is just physically stuff that happens, right? So hurricane or whatever, I mean, it hits, you notice the damage, the damage is obvious on Monday, by Wednesday you've got to get that notice out. That's all there is to it. They can't tell you what's insured and what's not. Now you've got to make inquiry about insurance, make sure that insurance will cover the damages. This is where you got to make inquiry. So let's say it's a good question. Okay, let's say that there's major windstorm damage, tree gets blown over, knocks out the half the house. But your buyer still wants it, assuming it can all be repaired, not on his dime. You get the notice in a timely manner. Now you've got 10 days left. My question back to the seller is, well, we want to buy the house, but we want to be sure that the insurance money's there. Get your insurance underwriter to tell us what they're going to do. And they need to tell us in the next 10 days. If they don't tell us in the next 10 days, then either I'm going to get out of this contract, or we can extend those 10 days so that the insurance company has time to get their adjuster out and tell us what they're going to do. Find out if you're satisfied with what they're going to do, then decide whether to proceed or not.
Should the buyer contact their lender on something like that? Something like that happens because money should be put in escrow if it's a large enough damage. And if the repairs
The question is whether you should contact your lender. And I think almost certain if you have major damage, I think the answer is yes, because the lender is going to want to is going to be very interested in whether the value of their collateral has been affected. And usually, you typically have an obligation to do that. That's a very good question. Yes, I would be contacting your lender, because your lender, in those circumstances, your lender will, and several other circumstances really, your lender protects you to some extent because they have an identity of interest with you. They want that collateral, and they want it as full value.
Can they recommend or demand that money's held in escrow until repairs are done?
I'd say they can make pretty much any demand they want to regarding how that money's held. You know, if the other side, if others in the chain of things don't want to comply with that, then obviously the deal's going to go south. But the lender has a definite interest in the quality of their collateral. Yes.
What if the deal closes and there's damage done to the property that's insurable, but it wasn't noticed by anybody? Let's say that it was, it was somewhat of a latent kind of issue, but it was clearly due to an insurable event that happened prior to the closing while the seller owned the property. The buyer buys the house, discovers the insurable event, and their insurance company won't insure it because the time that has happened on the sellers, when the seller owned the property, and then the seller's insurance won't, now the buyer's negotiating with the seller's insurance company. How do you deal with that?
Hire a lawyer. Is that 7? That's 7. Okay. No, I mean seriously, legally, if you think about an insurance policy insures you. It's an events occurrence policy typically. Okay, and they insure you for an event, for damage due to an event occurring during the time that the insured that the property is subject to that insurance. So yes, it's the seller's insurance. It happens however many days before closing. It reasonably should have been noted. A lot of questions start to happen. So the insurance company says, "Well, did you notice us in a timely manner?" All right. Should you have known what the damage? See what I'm saying? I mean, depends how all those questions get answered as to whether they're going to cover or not. And then you get in, and then that can just become a food fight.
Right, I thought when you changed the contract, this paragraph in the contract, you had to deal with that.
Well, I don't think you can, at the end of the day, this clearly states which party has responsibility. So in Ohio, at least, I think it's probably true in most jurisdictions, in Ohio, even though you have what's known as you have an equitable interest in a property as soon as you go into contract as a buyer, right? The insurable interest stays with the seller until the deed transfers, okay? That's the rules. So they've got the insurable interest, end of discussion. What this says is how things are, how the transaction proceeds if there's damage. But again, it's on the seller to comply with the terms of his contract with his insurance agent. If he didn't comply with the terms of the contract, the insurer can refuse to cover based upon that noncompliance. The buyer at that point, if it's a, well, we go back, the buyer at that point goes back to the general law of defects in the premises. Was it something he could have seen? Was it a latent? Was it an unknown latent defect, one that you can't see by ordinary inspection, but rears its ugly head later? Was it a latent defect known by the seller, who, if they know about it, they have an affirmative obligation to disclose it.
But it's like, you know, everybody in the neighborhood had similar kind of thing.
Well, the insurance company can argue that, shame on you, you should have called us. And you didn't. Anyone else? Well, conveniently enough, it's 3 o'clock, so let's take a break.